Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, performance test, other formats, and the 90-minute game plan, client/opinion letters, discovery plans, and a minute-by-minute time budget. Let's begin. Not every performance test asks for a memo or brief. The exam may ask for a client letter, opinion letter, demand letter, discovery plan, negotiation strategy, settlement evaluation, contract provision, witness examination outline, policy memo, or another practical lawyering document. These formats can feel unfamiliar, but the underlying method is the same. Follow the task memo, use the library for law, use the file for facts, and produce a document the intended audience can use. Other formats test adaptability. A lawyer often must translate legal analysis into practical action. A client may not need a full case discussion but does need to know risks, options, and next steps. A discovery plan may require identifying information needed to prove elements. A demand letter may require persuasive facts and a proposed resolution. A contract clause may require drafting language that solves a problem revealed in the file. The PT rewards your ability to match content to purpose. The 90-minute limit is the constant. Many students know what to do, but run out of time. A good game plan prevents overreading, over-outlining, and over-polishing. The goal is not to create a perfect legal document. The goal is to create a complete, organized, accurate, and responsive work product before time expires. For a client letter, write in plain language. The audience is usually not legally trained. Use a professional greeting if appropriate, a short introduction explaining the purpose, organized sections answering the client's questions, practical advice, and a clear closing. Explain legal standards without excessive citations unless the task asks for them. You can refer to the law or the court is likely to consider, rather than loading the letter with case names. The tone should be respectful, direct, and useful. For an opinion letter, be more formal and predictive. An opinion letter often gives a legal conclusion that the client or a third party may rely on. State assumptions, identify the question, explain the applicable law, apply it, and give the opinion with any qualifications. If the task asks for risks or limitations, include them. Avoid sounding more certain than the file and library allow. For a demand letter, combine persuasion with practical resolution. Identify the parties, summarize key facts favorably, state the legal basis for the demand, explain the harm or remedy, and request specific action by a specific deadline if the file supports it. Keep the tone firm but professional. Threats unsupported by the library or facts are not persuasive. For a discovery plan, think backward from the elements. What facts must be proven? What documents, witnesses, admissions, interrogatories, inspections, or subpoenas could establish those facts? Organize by issue or source. A strong discovery plan is not a generic list of requests. It is tied to the claims, defenses, and factual gaps in the file. If the library identifies burden or elements, use them as the plan structure. For a settlement evaluation or negotiation plan, combine legal risk with practical goals. Discuss strengths, weaknesses, likely outcomes, costs, non-legal interests, leverage, and recommended strategy. The file may include business concerns, reputation, timing, confidentiality, or relationship issues. For drafting tasks, such as contract clauses or policy provisions, read the instructions with special care. The answer may need actual language, not analysis about language. Use the facts to identify the problem and the library to identify required legal features. If time permits, add a short explanatory note only if requested. Otherwise, draft the provision clearly. Now use a minute-by-minute plan. Minutes 0 to 3. Read the task memo. Identify deliverable, audience, issues, exclusions, and format. Minutes 3 to 25. Read the library and extract the rule framework. Minutes 25 to 42. Read the file, build chronology, and tag facts to rules. Minutes 42 to 47. Finalize outline and headings. Minutes 47 to 85. Write the answer. Minutes 85 to 90. Review for completeness, headings, conclusions, and obvious errors. This plan is adjustable. If the library is short and the file is long, shift minutes to facts. If the assignment is a drafting task with less legal analysis, shift time to understanding the requested document. If typing is slow, start writing earlier. But do not allow reading to consume the entire exam. A written answer is the product. Use templates flexibly. For a client letter, headings might be our understanding of the facts, short answer, your options, risks, and recommended next steps. For a discovery plan, headings might be documents to request, witnesses to depose, admissions, and information needed on damages, or they might track elements like duty, breach, causation, and damages. For a settlement evaluation, headings might be liability risk, damages exposure, practical considerations, and recommended range. Suppose the task asks for a letter to a small business client explaining whether it should accept a proposed settlement after a supplier failed to deliver equipment. The file includes the contract, emails, lost sales estimates, the supplier's offer, and the client's concern about preserving a long-term relationship. The library includes rules on material breach, consequential damages, mitigation, and settlement enforceability. A memo-style answer full of case citations would not fit the audience. A strong client letter would begin by stating the purpose, to evaluate the settlement offer. It would briefly summarize the key facts, explain in plain language that the supplier likely breached because delivery was essential and late, caution that consequential lost sales may be difficult to prove unless they were foreseeable and well documented, discuss the client's mitigation efforts, and compare litigation risk with the certainty of settlement. It would end with a recommendation, such as accepting only if the supplier increases the amount or includes priority delivery, and a release limited to the current dispute. The legal analysis still exists, but it is translated into advice. That is the point of other PT formats. One mistake is forcing every format into a memo structure. If the task asks for a client letter, write a letter. Another mistake is forgetting the audience. Clients need advice and next steps. Courts need argument. Attorneys need legal analysis. Students also create generic discovery or settlement lists. Tie every recommendation to the file and library. A major mistake is ignoring practical facts. Business goals, deadlines, cost, confidentiality, and relationships can matter in practical formats. Some students fail to budget time. Running out of time is especially damaging when the format requires multiple parts. Use the 3-22-17-5-38-5 model as a default. 3 minutes task memo, 22 minutes library, 17 minutes file, 5 minutes outline, 38 minutes writing, 5 minutes review. Adjust based on materials, but protect writing time. If you reach minute 45 and are still reading, stop and outline immediately. During review, check the task memo against your answer. Did you write the requested document? Did you answer each question? Did you use the correct tone? Did you include a recommendation if asked? Did you avoid outside law? These checks are worth more than polishing style. Other PT formats use the same core skills. Use a minute-by-minute plan to protect writing time. A complete, responsive product beats an unfinished, perfect outline. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.